right, bailiff, if you're there, I'll need the jail court unmuted.
How's that, Judge?
That's better. All right, are you Adam Ray Sides? Say that again, I didn't hear you.
Yes, sir.
Okay, good. Mr. Sides, raise your right hand. I'm going to place you under oath. Mr. Sides, do you swear that the testimony you give to the court today, that it will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. All right, Mr. Sides, it appears that you have, with your attorney, executed a waiver of indictment. What that tells me in this document here is that you understand that you have the right to have your case presented to the Van Zandt County Grand Jury, and for that grand jury to decide whether or not the case should proceed with a prosecution. You understand that you and only you have the ability to waive that right of indictment and allow yourself to be prosecuted by the prosecutors on the filing of an information. Do you understand that?
Yes, sir.
And you've spoken with your attorney, Mr. Heath Hyde, and you're telling me today that of your own free will and accord, that you voluntarily want to waive your right to indictment and have your case presented to the court on the basis of an information. Is that right? Say that again. I can't hear you. Okay, make sure you speak up. My court reporter is here with me and she has to take down everything that we say. And Mr. Sides, have you waived this right of indictment intelligently, knowingly, and voluntarily, meaning no one's threatened you or forced you or made you waive your right to indictment? Is that right?
Yes, sir. I waived it voluntarily.
All right, court will approve the waiver of indictment in this cause. All right, Mr. Sides, you have been charged by information with a state jail felony offense of unlawful use of a criminal instrument. A state jail felony carries a range of punishment of not less than 6 months nor more than 2 years confinement in the Texas Department of Criminal Justice State Jail Division, and an optional fine not to exceed $10,000. You understand that range of punishment?
Yes, sir.
Are you a United States citizen?
Yes, sir. I am.
Do you read, write, and speak English?
Yes, sir. I do.
Have you ever been diagnosed with any type of mental condition?
No, sir.
And your attorney in this case is Mr. Heath Hyde. Are you pleased with his representation of you?
Yes, sir. I am.
You feel like you've had sufficient time to review your case and have all of your legal questions answered by him?
Yes, sir.
Mr. Hyde, do you believe your client to be competent today?
He is, Your Honor.
All right, Mr. Sides, to that state jail felony offense, how do you plead?
Guilty.
And Mr. Sides, are you pleading guilty because in fact you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to this charge?
No, sir.
All right, the court, understanding that there is a plea agreement in this case in which Mr. Sides, in exchange for his plea of guilt, is receiving the recommendation of the state that punishment be assessed at 24 months confinement in the state jail division of TDC, a $250 fine, the dismissal of filed cause number 2020-864, resisting arrest or transport, unfiled DA 2020-849, manufactured delivery of a controlled substance, penalty group 1, 4 grams to 200 grams, and DA 2020-353, possession of a controlled substance in penalty group 3, less than 28 grams, and finally DA 2020-352, evading arrest or detention. Court hereby accepts Mr. Sides' plea of guilt. In this matter, Mr. Hyde, is there any objection to the admission of States 1?
No, Your Honor.
All right, court admits States Exhibit 1 into evidence and takes judicial notice of Mr. Sides' judicial confession. Is there anything further from the state?
No, Judge. Rest and close.
Is there anything? Thank you, Mr. Hyde. Mr. Sides, I also need to ask you, throughout this document, your name appears I need to swear you through, this was not done by the clerk. I need to do this at this time. I'm going to show you your signature here. Is that your true and correct signature?
Yes, sir.
And by signing these documents, you're telling me that you've taken the time to read them or have them explained to you and that you understand everything that's contained therein.
Yes, sir.
All right, Mr. Sides, based on the evidence before the court's going to find that there is sufficient evidence to convict you of this offense. Court's going to follow the plea agreement in this case. Court hereby convicts you of the state jail felony offense of unlawful use of a criminal instrument. Court assesses your punishment in compliance with the plea agreement at 24 months confinement in the state jail division of TDCJ, assesses a $250 fine, dismisses the cause numbers previously put on the record by the court, and the court assesses a $290 court cost and $250 fines and a $15 reimbursement fee. Court awards you 123 days credit for the time that you have spent in jail on this cause. And Mr. Sides, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. Good luck to you, sir.
May I be excused, Your Honor?
Yes, thank you, Mr. Hyde.
Thank you, Judge.
Some right here for reset. It doesn't matter if the time of the signal record for this all. It's in there, I just don't have to sit down with you. Okay? No, it's gonna work the way it was going. I told you that. Not one. He's gonna know. We transferred all that discovery to him. So yes, same thing about it, okay?
Ms. Thompson, are you ready? Are you ready?
I'm
Yeah.
ready.
And Ms. Thompson, I'll only show you with one individual on my docket, and that's Judson Brown.
No, sir, I hit Mr. Ellis today for also jury docket.
This doesn't appear on my docket. Let me figure out why.
Judge, you might see Richard Schmidt's name next to this one.
Okay. Yeah, thank you, bailiff. That's exactly what it is. Okay. All right, we're set for a docket call today, Ms. Thompson.
Yes, sir. And, Your Honor, we, don't have anything, holding us back. We're ready.
Okay, so you've received an offer and your client rejects the offer.
That's
that right?
correct. Yes, sir.
And your client understands that if that same offer is extended later, or in fact, a different offer is extended later, the court may not entertain a plea agreement in this case.
Yes, sir.
Okay, then the court will set Mr. Ellis for jury selection on October 26th. And as you are aware of the court's policy, Ms. Thompson, you will not be required to appear on that unless you receive notice from the court that Mr. Ellis is in the top 10 or so cases that are liable for trial.
Yes, sir. I understand that. Is it gonna be at 1:30, Your Honor?
No, it'll be at, well, if he's in custody, he won't obviously need to appear. If he's out of custody, then he'll need to appear at 9 o'clock at the courthouse in the basement. If he's in custody, then it won't matter.
He'll be in custody, Your Honor.
If he's in custody, we'll do a reset notice and provide.
Thank you, Your Honor.
Thank you, Ms. Thompson. Are you ready on your other client?
I am, Your Honor.
Mr. Brown? This is CR 20150, State versus Judson Brown. Are we set for arraignment today, Ms. Thompson?
Your Honor, we're set for arraignment, but I also filed a motion to withdraw in this case. And I'm asking the court to allow me to withdraw from this case. We do not communicate well. I've been at great risk coming over here twice to see Mr. Brown, only to be spoken to very derogatorily, profanely, and even intimidated or attempted intimidation, and have him stomp out. And I just cannot, I don't feel I'm the one to assist him.
Mr. Brown,
Sir.
raise your right hand. Mr. Brown, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Sir.
All right. Mr. Brown, do you want to respond?
Yes, sir. I mean, twice she's told me that she works for the state and not for me. And I feel that it's not in my best, that she doesn't have my best interest at heart and trying to help me at all. I've asked her just to get me a motion to bench warrant. And she said that she's not going to do that because she doesn't do any of that for Dallas County. I just asked her just for the simple motion to bench warrant, and she wanted to tell me this and that. And then when she wants to start telling me penal codes, I told her, I said, well, I don't have a book of penal code right here in front of me to be able to do that. And then she wants to tell me that I should be grateful that I was getting the offer that I was the first time. And I said, no, that's not even right. And yes, I did use some profound every now and then, but I mean, not like directly to her.
Well, who was it directed to?
I was mostly cussing like, this is fucking stupid and stuff like that. I wasn't actually calling her anything. And I walked out the last time. I said, I'm not gonna sit here and argue with you. And I got up and I walked out. There's no sense in sitting here arguing with somebody who's gonna argue back and not be in my best interest.
I mean, wouldn't you agree with me when you start cursing and you're having a conversation with someone else, how is that other person to perceive that?
Well, when that other person's, I mean, telling me that they don't care about my life. I mean, I understand I did what I did, but I mean, at the same time, this is my life that I'm playing, that she has in my hands.
I understand, Mr. Brown. You understand that Ms. Thompson, as your court-appointed attorney, she does not have a legal duty to care about you. You understand that? She doesn't have to be your best friend. She doesn't have to like you. She doesn't have to talk to your mother or your sister or your grandmother. She doesn't have to send you postcards. She doesn't have to do any of that. Her job as an attorney is to zealously advocate and provide you for a defense. You understand that?
I understand that.
So she doesn't have to like you. She doesn't have to enjoy spending time with you. So what has she not done that you believe she's required to do?
Well, I asked her whenever they at the very first offer, she also asked the assistant district attorney about a 4-year offer. And I said, well, see if he'll do it too. She says, no, I will not do that. I will not ask him for that. I mean, isn't it all right to be able to say, hey, at least give me a 2? I mean, I'm counter offering. I mean, if she don't want to do that,
Ms. Thompson, do you want to respond?
Your Honor, we discussed at that particular meeting his enhancement levels and the problem with enhancements and what I would try to do. I did not get a request from him at that time to seek 2 years. I came in and told him about I had sought 4 years and that Mr. Cox said it was a possibility, but it was going to depend on what the enhancement level was. And we spent the time, our attention spent the time talking about the enhancements. I have never told him that I work for the state. This is something he gets up, stomps out of the room and says, you work for the state or you work for the court and leaves. I have no reason to tell him that. It's for these reasons, numerous reasons, I don't want to represent him.
All right, y'all both have a seat. Now, let me think about it. I'll call you back towards the end of the docket. Ms. Beasley, who do you have with you?
Austin Walker, Your Honor.
All right, court call CR 20-232, State versus Austin Lynn Walker. I believe we're set for arraignment today. Is that correct? And I'm sorry, this is also CR 20-200. I believe we're set for arraignment in each case, Ms. Beasley. Have you had a chance to review the indictment with your client?
I have, Your Honor.
Are you prepared for arraignment?
Yes, sir.
Go ahead.
Your Honor, my client's name is spelled correctly in each of the indictments. He understands the charges in each of those indictments, as well as the punishment range for the first degree and the second degree, and wishes to enter a plea of not guilty to both charges at this time.
All right, court will enter Austin Lynn Walker's plea of not guilty into the record in each cause. Court will set this for pre-trial. Ms. Beasley, before I do that, have you received discovery in this case?
Your Honor, I've received a 3-page document, but there is a ton of discovery that I've not received yet. So I would ask for an extended period for the next pretrial setting in order for we to receive all of that information.
State, when is Ms. Beasley going to receive all the discovery that you have in this case?
Your Honor, it's my understanding we're waiting on some documentation from the FBI, the U.S. Marshal Service. I can't tell the court when, hopefully sooner rather than later. I know Ms. Curry is in contact with those different federal agencies attempting to get documentation, but right now I can't give the court a time frame. It's federal agencies, not state agencies.
And I've already been discussing with the DA's office, and I know they have been trying to already obtain that information for me, Judge.
All right, the court's going to set this for pretrial on November 10th. Any scheduling issues that day, Ms. Beasley?
No, Your Honor.
We'll set this for Tuesday, November 10th at 1:30. Should he make bail, then it would obviously be set at 9 a.m.
Yes, Your Honor.
And I also want to set it that day for a deadline on getting the discovery in. Actually, I need to set that earlier. Mr. Cox, I need the evidence produced to Ms. Beasley so that she can file any pretrial motions. If we go back 7 days prior to that, her deadline to file would be November 3rd. So October 20th would be when the court would anticipate the deadline for the U.S. Marshal Service or the FBI or any other federal agency to have their reports to you since he's been indicted.
What was that date, Your Honor?
October 20th. And that'll give Ms. Beasley I'll tell you what, I'll extend it to October 27th.
Yes, sir.
Let me take that back, Mr. Cox. Let's go back to October 20th. That way Ms. Beasley has ample time to review that and still have time to file. She'll have to have her pretrial motions filed no later than Tuesday, the 3rd, November 3rd. So October 20th is probably what's fair in this case.
Yes, sir.
Anything else, Ms. Beasley?
And you said that my pretrial motions have to be filed by when, Judge?
By the time stated in the Code of Criminal Procedure, 7 days prior to the pretrial hearing, which would be November 3rd. The hearing's on the 10th,
So by November.
and that's statutory.
Yes, sir. May we be excused, Your Honor?
Is that all? Okay, yes. All right, Mr. Knoll, who do you have with you?
Judge, I have Timothy Royko, R-O-Y-K-O.
All right, CR 2192 and 2020-236. We set for arraignment today, Mr. Knoll?
That's correct, Judge. As far as the felony case, we have a copy of the indictment. We've reviewed it. The name is spelled correctly. And for the purposes of arraignment, we didn't plead not guilty. On the misdemeanor, which is a Class A misdemeanor, for the purposes of arraignment, we have reviewed that information. And for the purposes of arraignment, we enter a plea not guilty at this time.
All right, court will enter Mr. Royko's plea of not guilty into the record in each charge. Court hereby sets for pretrial. Have I given you some dates earlier this morning, Mr. Knoll?
Judge, you did October 13th. And as far as discovery, Judge, I think the only thing I need is probably a video that would actually involve both cases, but on the felony offense. And other than that, I think we have all the discovery. Now I will check with the DA's office regarding a video.
Okay, well, I want you to denote that on that notice of setting form. If you're missing discovery, that's what that box is for. I'll need you to write that in there. Court hereby sets Mr. Royko then for pretrial on October 13th.
Thank you, Judge.
All right, make sure he gets the yellow copy, you get the white copy, Mr. Knoll. I'm sorry, the court will get the white copy. Mr. Royko gets the yellow copy.
All right, thank you, Judge.
Judge Martin, it appears that we've exhausted our list of people who are prepared. I know we have Russell Melton for a capias pro fine. Would you like me to work him in on one of these slow times, or would you like to take care of your business first?
No, let's take care of what's on the docket first. I have Mr. Scott about to be available. We can take up his individual who's not an inmate there.
Okay, then I'll get Mr. Melton up here and just have him on standby then.
All right. Mr. Scott, when you're available, let me know. I see that you're trying to connect. There's no audio or picture at this time. Hello, Mr. Scott. How are you, sir?
Hi, Judge. Fine. How are you today?
Doing well, doing well. All right. I understand that you have an announcement on Mr. VZ CR 19210. I believe that we were set for pretrial and probably status on his incarceration at the Wood County Jail.
Yes, Your Honor. Still there. He wrote me a letter a couple of weeks back. He's waiting for this COVID stuff to go away so he can go to trial. He's at the top of the docket, jury docket.
Do you know if they're going to be conducting any jury trials before the end of the year?
I don't, Your Honor. His lawyer there got with me and said whenever it gets set, he'd like to get with me and have a meeting, and he hasn't done that yet. So as far as I know, there's no setting.
Okay. Are you still at the point where you need a pretrial setting? Have you reviewed the discovery with Mr. VZ? I guess what I'm really asking is, can we pass the pretrial setting and move to docket calls or statuses? Are there any contested pretrial motion issues that you think we're going to take?
I don't foresee any contested pretrial issues. But I wouldn't mind just putting the pretrial and status conference in one. I don't know if you'd do that, but just having those set together, just in case an issue comes up when it gets back over here.
Well, let's do this. At this time, I mean, we're set for pretrial. There's no contested pretrial motions filed. And so we'll set this for status, custody status. And should an issue arise, Mr. Scott, I'll grant you leave to file a motion for an additional pretrial setting.
That would be great. Thank you, Judge.
And we'll set this for status. Set it out a little bit longer. We'll set to November 10th. State, have any objection with that? They're muted. Hang on. Sorry, Mr. Cox, you may need to unmute. I had to mute you earlier so that we didn't pick up any of the.
How's that, Judge?
Better, thank you. Sorry. Mr. Cox, any objection to the court resetting this for custody status on November 10th for Mr. VZ?
Not at all, Your Honor.
All right, thank you, sir. All right, and Mr. Scott, if you'll just send notice to Mr. VZ or contact him however you do and let him know that his case will be on November 10th.
November 10th. Yes, Your Honor. I will.
1:30.
1:30.
All right.
Thank you.
Thank you, Mr. Scott.
Good to see you, Judge. Have a good day.
Good to see you. You too.
Hi, John.
Bye-bye.
All right, court calls CR 15-512, CR 15-513, State versus Michael Lee Doan Jr. I believe we're here on the state's motion to disqualify attorney. Mr. Manning, you had an announcement for the court on Mr. Doan's availability today.
Yes, Judge. As of yesterday, Ms. Abraham sent the reminder.
Here, come on a little closer because we don't have microphones out there. There we go, right there.
Ms. Abraham sent the reminder for the Segovia unit to set up the appointment. We never heard back one way or the other from them. This morning, she's attempted calling them, and she was just able to get a hold of them while we were sitting out there. She was informed that this morning, Mr. Doan was transferred to a trustee camp, but right now he is in an intermediate facility. And so we don't know what his final destination is going to be or how to reach him at this point.
So is he in flux about where his unit's going to be? Is the intermediate like a holding place as he's being shipped somewhere else?
That's correct.
All right, court's going to reset this hearing on the state's motion to disqualify, and we'll set this. Mr. Manning, did I set you earlier for any settings in October?
October 13th.
All right. Court's going to reset the hearing on this motion to October 13th at 1:30. And I'll ask that you and Ms. Abraham work together with TDCJ to see if we can find out where he's going to be and get that set so that we can have this hearing.
I believe that those witnesses may be excused.
Yes, sir. Thank you, Mr. Meany.
Yeah. Oh, right. We do have, yeah.
I've got pots on.
Cosmo.
where their decisions are now. Okay. We're gonna ask.
All right, are we ready?
Yes, sir.
Hang on just one moment, having some technical issues here. Just one moment. All right, apologize for that delay. All right, who do we have with us now?
Amanda Meek, Your Honor.
All right, this is cause number CR 2218, State versus Amanda Robin Eek. Show that we're set for arraignment and plea.
Correct.
And what's the proposed plea?
Your Honor, we are recommending 10 years confinement, TDC probated for 5 years with a $4,000 fine in both safety and mental health caseload as conditions of that probation. $290 in court costs, $845 in reimbursement fees.
And if I may, Your Honor, before we begin, we do have a question about the safety condition.
Yes, ma'am, go ahead.
While discussing the plea arrangement, Your Honor, my client is in full agreement of attending the safety as condition of probation. She doesn't have an issue with that. She would ask, since she's been in jail so long, that she be allowed to be released and submit back to the jail at whatever time the court or the probation department notifies her to submit herself back to the jail. I understand through discussing with various people, the court staff this afternoon, that there's been some issues with a similar situation on other people's cases. However, my client has a father who is very supportive and is trying to help her get into a women's shelter facility there in Longview. There's also another one that they're looking at that's in Abilene or somewhere in West Texas. That's also a women's facility that's catered towards women who have criminal cases and supports them and tries to get their life back on track. So she's asking that she be allowed to do this condition, but since it may take several months for a bed to be available, that she be allowed to go in, do her probation, and do the other conditions until that facility is open to receive patients.
And why do you believe it would be several months?
It has been in the past, Judge, and I know I've been told recently, as of today, they've accepted a few, but it's a slow acceptance. It's not a wide opening of accepting everybody yet.
And Judge, just for the record, because of Ms. Meek's medication, she will be waiting for the special needs safety campus. And I believe that will also affect the amount of time she will have to wait.
That is correct, Your Honor, because she has some mental health conditions that she's taking medications for.
And have y'all both worked with Ms. Burns to determine what our weight is, what any communication that we've had with Safe P is? Have y'all talked with her?
I believe Ms. Burns indicated to me that the projected wait time would be in excess of 4 months, 4 to 5 months.
She's indicated that is correct, Your Honor.
So the decision I make is you're telling me that she needs drug rehab and she needs to be on mental health caseload, but that if I keep her in, it's going to be 4 months to keep her in. And if I let her out, then she's not getting drug rehab. Is that about right?
If she gets to attend the women's shelter in Longview, she will be able to receive some outpatient treatment there at that facility, Your Honor. And she does have support of not just her father in this regard. She also has support of a family friend that's been in contact with me ever since she was first arrested. That's been a big support and will help assist her as much as she possibly can. That's the reason she's wanting to go to this shelter in Longview, because they've helped her previously and will continue to help support her.
And Ms. Beasley, I'm assuming you've talked to her, and because you referenced it earlier, that we had, I think about 8, we had less than 10 people that were waiting for safety. And the court ended up releasing them because I didn't know when the program was going to start back up. And I believe 99% of them have already violated and have lost their ability to go to safety. You talked to your client about that she would be in that same risk pool?
Yes, sir. She understands that she still has to abide by all the conditions of probation and do everything that she's told by probation in order that she can attend this program and be successful. Is that correct, Ms. Meek?
Yes, ma'am. Yes, Your Honor.
I'm not sure safety will ever take her if she's never in custody.
That's what Ms. Burns has indicated to me she believes.
Yeah, that's my belief as well. So I guess y'all have a decision to make. I guess the state and defense have a decision to make on how you want to resolve your case, with safety or without safety. Y'all want to spend some more time talking about it? Because let's just be, very blunt about it. I mean, if she needs drug rehab and you put her on the street for 4 months, you're setting her up for failure. And then when she comes back in and she's violated, like 99% of the other ones have, there's no reason to believe that she's not going to violate, despite what she says. She gets back out there and she's not equipped with the tools that she needs to fight her addiction. I mean, we're setting her up for failure. And so it's not an issue of whether or not I can let her out, but whether or not it's going to be in her best interest to do that. I mean, both of you ladies think that that's in her best interest?
If we could have a moment to talk real quick, Judge.
Sure. Sure, go ahead.
But there's a chance it could be 2 months, it could be 4 months or longer. And
And this would be the one chance you get to try to help with the three of them. And we do have a problem with them too on video. So my suggestion is, as much as I hate it, that you stay, so you can go into the safety building and get that behind you. Okay, and I'll let your friend know. Yes, she knows that there's a lot of it she can take, but those that have the X, she cannot. So you shouldn't be getting these three here, right? Are you here not taking them? No. But all the other ones you are. Okay. Those should be gone. So nobody can tell you, nobody can tell you, the one you will go, but we'll get you there as soon as it can. Okay.
All right, back on the record. CR 2218, go ahead.
Your Honor, my client, we talked about the condition of safety with the COVID conditions, and she agrees to stay in the jail until she has a bed available. She does want to attend the safety program so she can be successful.
Okay, and so let's do this then. Let's build in a safety feature in that if we can do a status check on her every 30 days. And then if let's say in 30 days, we still believe and we have no contact, we still believe that it's going to be 3 months, 4 months, then perhaps we can revisit whether or not she's released. That way she just doesn't go in and sit for 120 days.
Thank you, Your Honor.
Okay, then I think that's probably the best thing to do at the moment. Obviously that can change with more information.
Correct, Judge. And as far as the reset, is that just a date for the defense and the state to get together and probation to check on that, or does the court wish for another setting?
What I'll do is I'll work with the probation department. I'll have Ms. Burns keep track of that, and then she'll contact the court and let me know. That's what I did for my other safety people that were waiting. Is I'd keep a track on them, and then if I wanted a record, then I would just settle myself.
Okay.
So it won't be up to you, Ms. Beasley.
Okay. Just checking, Judge. I want to make sure.
I understand. I appreciate that. All right, Ms. Meek, if you will, raise your right hand. I'm going to place you under oath. Ms. Meek, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you put your hand down. And Ms. Heisel, Ms. Meek is pleading today to burglary of a habitation, second-degree felony.
That's correct, Your Honor.
All right, Ms. Meek, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Bipolar and psychosis.
And are you currently on medication for those today?
Yes, sir.
Do you feel like those medications are assisting you and giving you the ability to have rational thought and to understand the proceedings here today?
Yes, sir.
And you are represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Yes, sir.
You feel like you've had sufficient time to talk with her about your case and have all of your legal questions answered?
Yes.
And Miss Beasley, do you believe your client to be competent today?
I do, Your Honor. She's taking medications, but she's asked rational questions and seems to be clear of mind, clear of thought.
Good. And you've explained to her the advantages and disadvantages of her plea bargain. Is that correct?
Yes, Your Honor.
All right, Miss Meek, you are charged by indictment with the second-degree felony offense of burglary of a habitation. That second-degree felony carries a range of punishment of not less than 2 years nor more than 20 years confinement in the Texas Department of Criminal Justice, and also carries an optional fine not to exceed $10,000. Any sentence handed down by the court in this matter must be within that range of punishment. Do you understand that?
Yes, sir.
Now, understand that there is a plea agreement in your case in which you would plead guilty to that offense. In exchange, the state would recommend to the court that your sentence be assessed at 10 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on community supervision or probation for a period of 5 years, that you receive a $4,000 fine that as a condition of your community supervision, that you attend the Substance Abuse Felony Punishment Facility, also known as SAFE-P, and that you, as a condition of your community supervision, would be placed on the mental health caseload. And financially, you would be obligated to $290 court costs and $845 reimbursement fees for the court-appointed attorneys and other fees here in Van Zandt County. Is that your understanding of the plea?
Yes, sir.
And is that your understanding, Ms. Beasley?
Yes, Your Honor.
Then Ms. Meek, let me ask you then, how do you plead to the second-degree felony offense of burglary of a habitation? Guilty or not guilty?
Guilty.
And Ms. Meek, are you pleading guilty because you're guilty of committing that offense?
Yes, sir.
And Ms. Meek, has anyone threatened you, forced you, or made you feel like you had to plead guilty?
No.
All right, the court will accept Ms. Meek's plea of guilt. Ms. Beasley, any objection to the offer of States 1?
No, Your Honor.
States 1 is admitted into evidence, and the court takes judicial notice of Ms. Meek's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, and Ms. Heisel, can you give me a brief summation of the facts of this case?
Yes, Your Honor. Ms. Meeks was living on her sister and brother-in-law's property in a separate building. She entered her sister's house and went in and assaulted her brother-in-law. I believe the reason that she felt like that was appropriate was a combination of her substance abuse and her mental health issues. But she did enter that home and assaulted her brother-in-law. And that's basically the summation of how we ended up here today.
That is correct, Your Honor.
Okay, thank you, Ms. Beasley. All right, then based on the evidence presented to the court will follow the plea agreement in this case. Court hereby convicts Miss Amanda Robin Meek of the second-degree felony offense of burglary of a habitation, assesses her punishment in accordance with the plea agreement at 10 years confinement in the Texas Department of Criminal Justice. The court finds that it is in her and the community's best interest for that sentence to be suspended. She's hereby placed on 5 years community supervision. Court assesses a $4,000 fine. Court orders that Ms. Meek attend the SAFE-P program and be placed on the mental health caseload as conditions of her community supervision. Court orders her to pay $290 court costs, $845 reimbursement fee to Van Zandt County. Ms. Meek, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm going to have you step to your left to be fingerprinted with the bailiff, after which you'll be placed in custody for the fulfillment of the SAFE-P program. And Ms. Burns, I would ask that you place Ms. Meek on a 30-day notice and just notify the court of any progress with her being placed in the SAFE-P program, or if you receive additional information that may mean that she's in there for more than 90 days, anything more than 90 days, I'd be interested to know so that we can visit this issue again with Ms. Meek.
Yes, sir.
And I would just ask that y'all make sure that all paperwork has been signed. And Ms. Meek, I failed to ask you, but your signature is going to appear in that paperwork. I don't have that paperwork in front of me, okay? And so would you tell me that you signed that paperwork because you are attesting to me that that is your signature and that you're only signing because you understand everything that you read and signed or had explained to you?
Yes, sir. I signed all those papers this morning.
Okay, good. Well, I believe you did. I don't have them with me. And so I just have to swear that your signature is true and accurate. So I would just ask the state to make sure that the documents have all the correct dates and signature as required.
Yes,
Yes, thanks, Judge.
they should be excused, Your Honor.
Yes, thank you, Ms. Meek.
Thank you.
Judge, we're still waiting for some of the others to be brought up right now.
Okay, let's see. So it's Calvin Dunn.
one should be right now. This was your. Rachel Measure. Yes. Yes. Where are you at?
November 7th, I'm hoping that he provided some information on the check on history and get him a paperwork and try to get him by that time. Okay.
Ms. Heisel?
Judge, we have a reset for Michael Mason. He's in the Gregg County Jail currently. And Ms. Beasley and Mr. Cox are in discussions about resolving that case. So we're asking for a reset to November the 10th.
November the 10th?
Yes,
That is correct, Your Honor. We're in hopes of being able to have it resolved, mail the plea papers to him, to one of the sergeants at the jail in Gregg County. She will contact me and hopefully schedule a telephone conference so I can go over the paperwork. He can sign it at that time. They can get his thumbprint or fingerprint and then mail it back to me through regular mail, and hopefully we'll have it by November.
Okay. CR 25-6, State versus Michael David Mason. The court sets Mr. Mason for plea on November 10th at 1:30.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Is that all you have, Ms. Beasley?
Yes, Your Honor.
All right, thank you.
No cold feet.
No. I just need to verify.
Okay, Reagan.
Keep that on the table. We're working on it.
Okay.
Mr. Adams, yours are on the way. You need a reset form?
I got one.
You got it, okay.
What Mitchell wants. Mr. Adams, are you ready?
Ready, Your Honor.
And who do you have with you?
This is Samantha Joe Melvin, Your Honor.
This is CR 21A2, State versus Samantha Joe Melvin. I believe we're set for arraignment today. Is that correct?
That's correct, Your Honor.
Are we ready for arraignment?
We're ready, Your Honor.
Go ahead.
Your Honor, Ms. Melvin, I'll represent to the court that Ms. Melvin's name is properly set forth and spelled in the indictment, that she understands the allegation made against her in the indictment. And at this time, we're going to enter a plea of not guilty to that charge. However, it is also the case that we, Ms. Melvin and I, have reached a plea agreement with the state. And so what we would like to do from here, rather than set this for pretrial, is to set it for a plea and sentencing here.
Is it going to be a plea for time or probation or
For time, Your Honor.
for time? Okay. And do you want to do that sooner than later?
Sooner rather than later, yes, sir.
Our next criminal docket is on the 29th. That'd be 2 weeks from today. Or Thursday of this week.
I have a contested family final hearing in the only family law case that I have, and that's probably going to chew up most of the day. I'm going to be here anyway on the 29th.
Okay. All right. Then court will enter Miss Melvin's plea of not guilty into the record for purposes of arraignment, and court will set her for plea on September 29th at 1:30. And Ms. Melvin, to get the yellow copy, court will retain the white copy.
Yes, sir. Your Honor, I think that's all that we need to do with Miss Melvin at the moment.
Yes, once she gets her notice, she's free to go.
She has it. Okay. So, yeah, I'll see you on the 29th. Yeah.
All right, court calls CR 18-472, CR 18-308, State versus Calvin Leroy Dunn. We're set here today for status on the court's in-camera review of the CPS records. The court has not completed its review of the CPS records. I wanted to give you an update about that, Mr. Adams and Mr. Dunn. The court had delivered to it 14,204 pages of records. So the court has been working through those diligently, but I have not completed my in-camera review of those. So just kind of wanted to give you an idea of how many records were sent to me and what I've been doing. So I'm going to need to reset this for some additional time for me to complete that. And so,
And you have my sincerest apologies about that, Your Honor.
oh, that's okay. It's okay. I just wanted you to know why it's taken as long as it has. I didn't want Mr. Dunn to think that I've just been putting it off.
Totally.
So,
I understand.
so what I'm going to do is reset this just for a status on the CPS in-camera review to October 20th. Do you have any scheduling conflicts that day, Mr. Adams?
Oh, thank you, Your Honor. I'll double check real quick. No conflicts, Your Honor.
All right, we'll set that for October 20th at 1:30.
Yes, sir.
And I hope to have my review done before then and the order out to you before that hearing. And then we can take up any matters collateral to that at that time.
Yes, sir.
Is this Mr. Vaughn?
Yes, sir.
All right, court call CR 295, State versus Michael Lee Vaughn. I believe that we're set for docket call today, Mr. Adams.
That's correct, Your Honor. Actually, Your Honor, we have signed and executed plea papers. And so we're ready to proceed with a plea and sentencing hearing.
All right, is he going to be pleading guilty to the indictment charge of third-degree assault of a family or household member by impeding breath or circulation?
Yes, Your Honor. That's correct.
And Ms. Heisel, what's the terms of the plea?
Your Honor, it's for 3 years TDCJ institutional division, a $4,600 fine, $290 in court costs, $20 in reimbursement fees, and 153 days credit back time.
And Ms. Heisel, you've reviewed the documents and ensured that Mr. Vaughn has signed in every place that he's required to sign?
Your Honor, I am looking through. I do believe Mr. Vaughn has signed everywhere. The only blanks are where the clerk is not here to those.
Okay. All right, Mr. Vaughn, if you will, raise your right hand. I'm going to place you on oath. Mr. Vaughn, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may lower your hand. All right, Mr. Vaughn, you are Michael Lee Vaughn.
Yes, sir.
And Mr. Vaughn, do you read, write, and speak English?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
ADHD.
Are you on any kind of medication for ADHD?
I haven't been since I was 14.
Okay, and how old are you now?
I am 36.
Okay. And you're represented in this case by Mr. Mitch Adams. He's your court-appointed attorney. And are you pleased with his representation of you?
Yes, sir.
Feel like you've had sufficient time to review your case with him and have all of your legal questions answered?
Yes, sir.
Mr. Adams, do you believe your client to be competent today?
I believe so, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor.
All right, Mr. Vaughn, you are charged by indictment with the third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years nor more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. That means any sentence you receive must fall within that range. And you were present when Ms. Heisel informed me what the plea agreement was. Is that your understanding of the plea agreement?
Yes, sir.
And yours as well, Mr. Adams?
That's correct, Your Honor.
All right, Mr. Vaughn, understanding the range of punishment and what you've been charged with, how do you plead to that offense?
I plead guilty.
And Mr. Vaughn, are you pleading guilty because in fact you are guilty and for no other reason?
Yes, sir.
And has anyone threatened you, forced you, or otherwise made you feel like you had to plead guilty?
No, sir.
All right, the court will accept Mr. Michael Lee Vaughn's plea of guilt. Mr. Adams, any objection to the admission of States 1?
No objection.
Court admits States Exhibit 1 and takes judicial notice of Mr. Vaughn's judicial confession. And Mr. Vaughn, throughout the documents, your signature appears there. Is that your true and correct signature?
Yes, sir.
And you've signed acknowledging that you have read and reviewed or had those documents explained to you and that you understand them?
Yes, sir.
All right, thank you, sir. All right, anything further from the state?
No, Your Honor.
Anything from the defense?
No, Your Honor, we rest.
All right, and Ms. Heisel, if you'll give me a brief summation of the facts.
Yes, Your Honor. Mr. Vaughn and his wife are from the Austin area, and they were in Van Zandt County visiting when they became involved in an argument. Mr. Vaughn physically assaulted his wife and also choked her in the course of that argument. As his wife was calling for help, a third party, just Good Samaritan, stopped and called 911 and assisted her, and Mr. Vaughn left the scene. She told the officers that when he was choking her that she was seeing black spots and thought she was going to pass out, and that this all occurred while there was an active EPO out of Travis County from, I believe it was within a month of the assault that happened here. But we are proceeding on the impeding charge, Your Honor.
Mr. Adams, any objection to that summation?
No objection, Your Honor.
And Ms. Heisel, is there any victim concern as to whether she supports or doesn't support this plea agreement?
Judge, to my knowledge, we have not received communication from her one way or the other, other than us sending her out the notice.
What about you, Mr. Adams? Have you had any contact with the victim?
I haven't, Your Honor. All I have is a copy of the notice that the state sent out to her, to Ms. Vaughn.
Okay. All right, then based upon the evidence presented to the court will follow the plea agreement. Court hereby convicts you, Mr. Vaughn, of the third-degree felony offensive assault of a family or household member by impeding breath or circulation. Assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice. Assesses a fine in the amount of $4,600. Court costs of $290. Orders you to pay reimbursement fees of $20 and hereby issues you credit for 153 days time served on this matter. Mr. Vaughn, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of this sentence. Good luck to you, sir. I'm gonna have you step to your left and be fingerprinted with the bailiff.
Your Honor, unless there's something else that you need me to hang around for, that's all the business I have. I'll be excused.
Well, you know, hang on just a second. Let me see what Miss Taberham says about that. She's sitting here next to me and
Sure.
she says she likes to pick on you.
Please.
Most of all.
Let's check with Ms. Taberham.
Miss Taberham, tell him, is he free to go?
Today you are.
Did you hear that? She said today you're free to go.
All right. Tell her the stakes are in the mail.
Thank you, Mr. Adams.
Thank you. That's $100 discrepancy on fine. In one place it says 46, in other place it says 45. 45.
You just interlineate, I'll sign it. That's just right rules.
So is that-
I just read it wrong, because I did read it on the record wrong.
Tiffany McElish.
Mr. Cox?
Yeah, I got it started.
Do you know if Mr. Knoll left?
I believe he did.
There you go. Count us. Mr. Vaughn, keep head down. All right.
Mr. Bond, you are done. You will get copies to you eventually, but just have to just not visit this. Sure, you guys can go back.
No.
He's here for a case profile.
Okay, I was gonna say, I don't know.
We have extra bodies.
I'm not great at math, but I can count to 1 and 2.
I saw him on camera with one.
I had an attorney.
Oh, is it? Love it all.
Said I have an attorney.
I don't think they're,
Mr.
I don't know
Cox,
if he's like an associate
he's
or a
asking if
partner.
he
I
can
think he
speak
just.
to y'all about.
In,
Yeah.
yeah, shares the space.
What's the name?
Melton, I'm sorry. Russell Melton.
I just wondered if I could get it resolved. From November of last year.
Shows you got a lawyer on that one. Floating Sawyer?
They told me I didn't have a lawyer, so. I missed court on it.
Oh, I don't have the opportunity.
Oh, he's at a Tyler.
I didn't know he was upstairs on the paper, but I know he's back at this down.
Oh, it's a mystery.
Okay.
Is there any way I can just get time for counsel on it?
All right, I'm ready on Judson Taylor Brown.
I'll talk to you in a minute.
All right, so the court has reviewed the motion to withdraw as counsel, and there's also a motion seeking bond reduction. Did you file that one, Ms. Thompson?
Yes, I filed it in case the court did not relieve me, then I wanted to seek that on his behalf.
And Ms. Thompson, you're still asking the court to allow you to withdraw?
Yes, sir, I am.
And Mr. Brown, you're asking the court to allow Ms. Thompson to withdraw as your counsel?
Yes, sir.
All right, the court grants the motion to withdraw as counsel. Ms. Thompson, do you know how much you're going to bill?
It can't be all that much, Your Honor. I don't know. I have not even figured it out, but I made 2 visits out here, so I did. Couple calls.
All right, so Mr. Brown, you're going to be responsible for Ms. Thompson's bill in this. I want you to know that.
Yes, sir.
And if you want to verbally abuse an attorney, why don't you go hire your own attorney?
That's what I'm still working on. It's kind of
Work
hard
harder.
when I'm locked up.
Work harder. Work harder. You understand? And then
Sure.
you can pay them and you can verbally abuse them all you want. I'm going to appoint you another attorney, and that person is going to show up out there. And if I hear 1 ounce of profanity or anything like that from another attorney, you and I are going to have serious problems.
Sir.
We're clear?
Sir.
Your Honor, may I be excused?
Yes, and the court's not going to take up the motion to seek bond reduction at this time.
Yes, sir.
All right, Mr. Brown, I'm going to reset you for arraignment on October 13th, 1:30, and your new court-appointed attorney will be in contact with you. I'll have some paperwork sent out there to you with the new attorney's name, number, and contact information.
Thank you, sir.
All right.
Yes, sir.
How long you been in?
Well, I had 12 days and then I got a PR bond and I guess they went off my PR bond.
All right, bailiff, I believe that wraps up everyone except Mr. Melton on the KPS profile. Is that correct?
That's correct, Your Honor. He's currently talking with Mr. Cox about a charge.
Does he have a lawyer?
They're working that out, sir. I don't know the status of that. But I had it muted so that they could talk in private.
Okay, that's fine. Do that.
Mr. Melton, would you come on up here to the podium, sir?
Oh, yeah, I saw that. I haven't gotten around to reading it yet, but. I can hear you.
he will not allow me to do that.
Aye.
Mr. Melton?
Sir.
You're here today on a KPS profile warrant for two cases. CR 13-490, and in that case, you were charged and convicted by plea agreement of abandoning and or endangering a child with criminal negligence back on September 24th of 2013, and then also in cause number CR 13-491. Give me a moment, I'll pull that case up. In that case, you were convicted on September 24th, 2013 of the same charge, abandoning or endangering a child by criminal negligence. And in each one of those cases, Mr. Melton, you were assessed a fine, court cost, and it appears that you did not discharge the fines and court costs that you were ordered to pay. I show that you owe $1,750 approximately on one case and $2,650 on another case. Do you have the funds to discharge what you owe so that you can be released on those charges?
No, sir. Not right now. Yeah.
Not for what?
I mean, I'm in jail, so no.
Well, no, I get that, but just because people are in jail doesn't mean they don't have friends, family, or access to money.
No, I don't.
How come you didn't pay these off?
Really, I forgot about them.
So you had the ability to do it, you just forgot about it?
Well, I probably had the ability to do it in the amount of time. I mean, but I don't know. I guess.
Yeah, because that was 7 years ago.
Yes, sir.
Probably could have paid them off in 7 years on a payment plan, right?
Of course.
Were you working during that time?
Here and there, yeah.
I mean, you were taking care of your basic needs and supporting yourself?
Yes, sir.
All right, Mr. Melton, and you're telling me today you don't have the ability to pay any of this off?
Not as we speak, no, sir.
All right, the court's going to find that you had the ability to discharge your fines, fees, and court costs, that you're not indigent, and you failed to make a good faith effort to discharge the fines and court costs. In cause number CR 13-490, court is going to order you to serve 18 days confinement in the county jail. You'll receive 16 days credit for time already served. You'll have an additional 2 days to serve in that case. In CR 13-491, court's going to assess you 27 days in jail. You'll get credit for 16 days. You'll have 11 to serve. And that will discharge what you owe. And you are getting the statutory amount of $100 per day credit towards the discharge of these monies owed. You understand? So after the expiration of those time frames, then you'll no longer owe that to the county. All right?
Yes, sir. I'm kind of confused here. So I have how many more days left altogether on it?
You have 11 more days you have 11 more days total. You have 2 on one and 11 on the other, so 11 total.
Okay, thank you.
Do you have any other charges pending?
Yes, sir.
Okay. All right, well, that has, this KPS pro fine order has nothing to do with your other pending charges.
Right,
Okay. All right, you're free to go.
thank you.
Bailiff, is that a wrap?
Looks like a wrap on this end, Judge. Is there anything else we can do for you before I sign off?
I don't think so. You know how to do a Irish jig or anything?
No.
Okay, all right, then I
You?
guess, of course I know how to do that. I know how to do everything.
We'll let you demonstrate next time we Zoom then.
Absolutely. I'll put it on YouTube. See y'all later.
Thank you, Judge.